Welcome to another episode of the Federal Newswire Lunch Hour Podcast with your host, Andrew Langer.
Well, hey there, everybody. Welcome to another episode of the Lunch Hour with Federal Newswire. I'm your host, Andrew Langer, and if you're watching us on our YouTube channel, you can check out the podcast version itself. You can take it wherever you go, listen to it on your headphones, wherever leading podcasts are found. If you're listening to us on one of those podcast platforms, you might want to check us out to see what's happening in studio here. Go to our YouTube channel and please leave us a like, please subscribe, leave us a review, and let everybody you know about the Lunch Hour with Federal Newswire. So this is one of those rare podcasts where I get to talk to somebody that I've known for a very long time and someone who figures very prominently in my own life story because, of course, it has to be all about me here at the Lunch Hour. I'm being joined by Roger Marzulla. He is one of the nation's leading water, property, and environmental lawyers. As Assistant Attorney General in charge of the U.S. Department of Justice's Environment and Natural Resources Division, Roger learned firsthand the operations and litigation styles of his client agencies, EPA, Interior, U.S. Fish and Wildlife Service, and many others. He began his legal career as a trial lawyer in San Jose, California, after graduating magna cum laude from the University of Santa Clara School of Law. In 1981, he moved to Denver to become president of the Mountain States Legal Foundation, litigating environmental and natural resource cases across the West. At the Justice Department, Roger helped create litigation strategies for government programs such as diverse as Superfund, the Clean Air Act, offshore oil leasing, environmental crimes, federal facility cleanup, wetlands, endangered species, and hazardous waste enforcement. He was also one of the authors, if not the author, of Presidential Order Executive Order 12630, which is what we know as the Executive Order on Takings or government interference with private property rights. In 1989, Roger returned to private law practice, successfully heading the environmental law practices of the Powell Goldstein and Akin Gump law firms, which is where I first met Roger. In 1997, he co-founded Marzulla Law with his wife, Nancy, where he brings to bear more than 35 years of experience representing companies and individuals in industries as diverse as land and project development, aerospace, chemicals, oil and gas, mining, timber manufacturing, computers, agriculture, and water service. His practice focuses on federal takings claims, contract claims, water rights, and environment and natural resource matters. And Roger has the distinction of being one of my first bosses. I'm going to talk about this later on in the show, Roger, and how important that time was to me, but want to welcome you to the show. Good to have you here.
Thank you. Well, Andrew, it's a real pleasure and to be able to sum up all those years that we have been together off and on.
Right, that is exactly right. And Roger, I didn't mention in the bio, Roger is the author, along with his wife Nancy, of the book Property Rights, Understanding Takings and Environmental Regulation. And let me ask you this, Roger, because this is the theme, obviously, throughout your professional career. Why property rights? How did you get interested in property rights? What's the story there?
Well, it started very early in my career, fresh out of law school. I went into a local law firm in San Jose, California, that specialized in real property law. And right in my lap landed a constitutional case dealing with the use of land and the county's attempt to impose various fees and exactions for development and use of that land. So actually, my second year in law practice, I found myself before the California Supreme Court arguing about the Fifth Amendment to the Constitution of the United States and how property could not be taken, according to the Founding Fathers, without just compensation. I became fascinated by that issue specifically as one of the key guardians of our civil liberties, the ownership of property, the ability to retain the fruits of your labors. And from that time on, I've been doing property rights law in one form or another, in government, in private practice, in public interest law firms. And now talking with you about it.
There you go, of course. And so for a long time, for a good, I would say, 60, 70 years, property rights, in terms of constitutional law, in terms of Supreme Court case law, were relegated to the status of poor relation, Not so much so anymore. We seem to be very much in a property rights moment, or at least half of the last 15 years. Talk about what's changed in terms of the Supreme Court's view of private property rights.
Well, you're absolutely right that for a lengthy period in the last century, probably from the early years of the century up to the 1980s, we found the courts who follow the lead of the Supreme Court um, not paying as much attention as we would wish to the individual rights in property, and feeling that the claims of society in general uh, overwhelmed those of the individual property rights holder. During the Reagan administration, where I had the opportunity to serve in the Justice Department, there was a group of us, as you know, Andrew, because you can talk about it, who attempted to breathe life again into the property rights protections that the Founding Fathers enshrined in the Constitution. And we were able to get the Supreme Court to take some cases, to make some good decisions. And from that point on, property rights have seen a resurgence, I think, in a recognition that, frankly, communal systems, the tragedy of the commons,
Right.
is not protective of individual rights and ultimately simply results in a poorer society.
Yeah, we had a conversation with Rob Gordon, who used to be on the Resources Committee and later went over to the Heritage Foundation.
Good man,
I know
Rob.
You know him. Yeah,
Yes.
Rob's great. We're sort of talking about these issues and the tragedy of the commons and how that brings these things up. Let me sort of get into the nitty gritty here, because
Sure.
These are conversations you and I used to have. That there are different elements, right? The Fifth Amendment, in addition to the self-incrimination portions, talking about the property rights aspects of the Fifth Amendment, right? There are two
Yes.
elements here that we've given government the power to take private property, right? That's a power we've given government to do. But two things have to happen. Three things actually. That it has to be for a legitimate public use, that due process has to be accorded to the property owner, and I want to talk especially about due process. And then, of course, just compensation has to be paid. And most of these property rights cases deal with some aspect of that. The question of whether or not it's a public use is certainly more of a question we've been dealing with in recent years. But the issue of due process and then the issue of compensation. Let's start with this. Let's talk about the Supreme Court case law on this issue of what constitutes public use. We had that case out of what was it? New Haven, Connecticut. The takings case there.
The Kelo case.
The Kelo case. Thank you.
Yes.
I was having a brain freeze there, Roger. I apologize. So talk about Kelo case and the issue of public use, and then I want to get into due process.
Yes. Well, to take a step back then,
Please.
The whole nature of what is called the power of eminent domain is an inherent power of government to acquire private property for necessary public works. You can't build a road without piecing together various portions of property, and the government needs to then acquire that property. It has the right to do that. That is called the right of eminent domain. It's also called condemnation.
Yeah.
The nature of that right is that it has to be conditioned on something that is either the government can take your property and just say, tough luck, you're the guy who loses out. And that certainly happens in dictatorships around this world. Or you adopt our constitutional process, which says that if private property is taken, A, it must be for public use, and B, there must be just compensation. The public use issue, frankly, has faded to some extent in the wake of the Kelo decision that you mentioned, because that was a case involving a redevelopment of an area that was done for the purposes of creating an industrial park. for a major pharma company. And in fact, we find that local government, not unusually, will delegate the power of eminent domain to companies. We've fought that over the years, but the bottom line is the argument the Supreme Court was faced with was, is it really a public use when a private company gets to go out and take people's private property in order to create their own industrial park and build their own offices and labs and whatever else they were building there. One of the little landowners, Mrs. Kelo, had a little pink stucco house,
Yep.
and she said, "Hell no, you can't
Yeah.
have my house because you're not taking it for a public use." The Supreme Court, however, decided that public use included redevelopment, or redevelopment included public use, and that therefore private property could be taken even if the title didn't go to the government, it went to a private party.
Roger, does the Kelo decision, does that underscore the one of the flaws in the concept of stare decisis, the idea of relying on precedent? I mean, it seems to me the only reason why Kelo was allowed to happen is that the Supreme Court was able to rely on 100 years of precedent that essentially had led us to the point where public benefit equaled public use.
Yes.
That was an opportunity there, right, for the Supreme Court, but because we, for whatever reason, we have this, focus on, and I understand we need to have consistency in Supreme Court case law, but we can't be, unwilling to revisit things when things have gotten far out of hand. Talk about that a little bit.
Well, that's right, and
Yeah.
we have seen in this, the current Supreme Court, a willingness to reopen some decided issues in the past and to try to get the law back on track. And mind you, that is not just a function of this Supreme Court. I'm mindful of, I think of the Warren Court back in the 1960s and 70s that overturned all sorts of civil rights, criminal prosecution, kinds of areas of decision, and created new law and basically reversed prior decisions. So the law, our law, consists of really two major components. It's statutes that are passed by the court.
Sure.
And I mean, passed by the legislature.
Yeah, of course.
And decisions that are made by the court. And that's what's called the common law system. And so the court will look to its prior precedents. How did we decide this issue before? We figured it out and hopefully came to the right decision. So we'll kind of follow that precedent. Well,
sorry, go ahead.
Well, I was just going to say, but sometimes the court realizes we actually got it wrong, or we didn't realize what would be the results of this decision, and they reverse course and invalidate the prior decision and refuse to follow the prior precedent.
I was going to come to this later, but this is a good entree for this now, because we've got these two major cases that are happening in the Supreme Court this term. One that was just announced, the Relentless case, and I can't remember the name of the other one, but it's
Yes.
both having to do with. Sorry, yes, go ahead. So, Loper Enterprises, but have to do with Chevron deference, which is something I first learned while working with you about the concept of Chevron deference, but also having to do with regulatory, at least as clear as I can tell, regulatory takings issues. The idea that if you that an agency can say, hey, we're going to put a monitor on your boat and we're going to make you pay for this monitor, which is like, to me, a clear taking. But talk about the elements of these cases and talk about Chevron. Actually, start with the takings claim aspects of it, but then we'll get into Chevron.
Yeah, of course, these cases aren't takings cases. There are two takings cases that I'd love to talk with you about as well.
Sure, absolutely.
Before the Supreme Court this year. But the whole notion of Chevron deference goes back to a 1984 decision of the Supreme Court, in which the court was attempting to determine whether an EPA interpretation of a Clean Air Act provision that the interpretation included in a regulation was faithful to the Clean Air Act that Congress had passed. And the court created, in that case, Chevron versus Natural Resources Defense Council, what has come to be called the Chevron deference rule. What it said is, the agency, EPA, they're really the experts here. They know what's going on with the Clean Air Act, and they ought to be able to interpret it for us. And, what does a judge know, after all, about clean air and pollution regulation and how to deal with pollution problems? So if it's a choice between some judge sitting there trying to figure it out in his or her black robes and these experts over at EPA, let's go with EPA. Let's give deference to their conclusions. And on the face of it at the time, it seemed an entirely reasonable decision. But what has happened then over the years is the agencies have grabbed hold of this Chevron deference notion. And it has grown, just as we just discussed, about precedent and precedent getting out of hand, such that the agencies, first of all, interpret their own jurisdiction, the breadth of what they can do. So Congress passes a law saying the agency can do X, and the agency says, well, X includes A, B, and C, so we're going to do that. And that actually is exactly what is before the court in the fishing cases you mentioned. These are cases in which, under federal law, under a statute passed by Congress, fishing companies are required in many instances to carry aboard them federal employees called observers, whose job it is to see that the fishing boats comply with the various requirements of federal statute. Those include the protection of endangered species and mammals, be they whales, dolphins, whatever, with quotas for how much fish can be caught, with methods that are allowed and avoiding methods that are not allowed for the catching of fish, and so forth. Well, the statute says that the fishermen can be required to take these observers, but it says nothing about who pays them. In fact, Congress has authorized money to pay these observers. They're employees of the federal government, and they get federal government checks. But the relevant agency, the National Marine Fisheries Service, decided that they were running short on funds, so they have required the fishing companies or the fishermen, and these are usually people who have very tough jobs, and they're not making a lot of money. They're one of the most dangerous jobs in this country, being out on the open ocean in all kinds of weather and so forth and so on. Anyway, have required these fishermen to start paying parts of the salaries, reimbursing salaries for these observers that the government requires them to carry with them. I mean, after all, the fisherman doesn't want these landlubbers on their boats. They're just in the way, and they have to take care of them and give them, food and lodging and all the rest on the boats. These boats are often out for months. Anyway, there's nothing in the statute Congress passed saying the fishermen have to, insult to injury, salt in the wounds, have to also pay these people.
Wow.
But the agency interpreted the statute to say, well, if the fishermen have to have these people on their boats, they ought to be required to pay part of it, don't you think? And so the Court of Appeals has upheld that. The Supreme Court has granted review. And we're hopeful that the Supreme Court will look at the deference analysis that was used
Sure.
by the Court of Appeals. Court of Appeals said, well, we don't see anything in the statute. It's silent on
Yeah.
any payment. So we will defer to the agency because the statute is silent. Well, that's exactly upside down, isn't it?
Right.
If the statute doesn't say the agency can do it, how does the agency say, well, yeah, we can? We just interpret it to say we can do what Congress didn't say we could do. So you see how the precedent has gotten out of hand.
Roger, how is it? But and so I guess so was there ever a takings claim raised, or did they never go down that road? Why? Because it seems to me that this is also violative of the Fifth Amendment. But what are your thoughts here?
Yes, well, there are some takings issues that I'd love to explore.
Sure.
We actually did back, I think, even in your time, deal with some tuna boat observers.
Maybe,
and there were certainly claims that forcing federal officials to be on boats that, after all, are themselves private property is an invasion. That was too early, I think, in the development of modern property rights law for that issue to have been decided correctly. But it may be time now to revisit both that issue and, of course, the issue of insult to injury, requiring that the fishermen pay these observers.
Not for nothing, but I was just having a conversation with someone who works with one of the major auto manufacturers. Yeah. And they have and this actually ties in together the relationship, at least as clear as I can tell, between property rights and free speech rights. So a major company, they are required by the Department of Transportation, NHTSA, I believe, to have an observer in their office and an observer's team to correct some past problems. And they're paying huge sums of money for this. Yes. And yet they can't say boo about it because they don't want to have it continue down the road. It's like,
of course.
So yeah. So let's this issue of deference and this issue of interpretation gets into the example that I tend to use is the old the ranch case that you and I dealt with. I assisted with back in the 90s. The ranch up in the high desert of Nevada that they had to put under 6 feet of water every year, and through the vagueness and the lack of definition in the statute and the Clean Water Act of polluting a navigable water of the United States, because they never defined what navigable water of the United States was, a patch of land in the high desert of Nevada was considered a navigable waterway. So many of these things hinge on this idea, this expansive ability for agencies to do this, the ESA and other ways. I don't want to talk about it, but that's really what we're talking about here. Is this is how we get a regulatory state that's $2 trillion in size, $3 trillion in size? Is it?
Absolutely. Yeah. Well, absolutely, and it's slovenly government as well.
Yeah.
The whole structure, the whole theory of this deference, the Chevron deference, is that Congress passes the buck to the agency in the first place. Congress says, I don't know what to do about wetlands or whales or whatever, so we'll just give it to some unelected bureaucrat. Let them come up with some rules.
I was just saying, I was testifying on that up on the Hill probably about 15 years ago. And I had a congressman who wanted me to beat up on the agencies, and I was happy to do that. Yeah. But he said, whose fault is this? I said, well, Congressman, it's your fault. If you guys would just pass laws that weren't so vague.
Exactly.
Sorry. Yeah.
Exactly. So what happens is then Congress is effectively leaving it up to the agency, the bureaucrats, to define what the law is and what it is they are or are not supposed to do. Like make the fishermen pay for the observers on their boats, or make the observers be on their boats. And so the agencies, and this is kind of the second blow under the Chevron doctrine, the agencies have figured out, if we write our regulations so they're kind of vague, so nobody really knows what they mean or what's right and what's wrong, then we can come out with an interpretation of our regulation. And the court, under the Chevron doctrine, is going to say, well, the agency is the expert. And after all, they wrote the regulation. They must know what it means. And Andrew, you violated it
Right.
because you thought that was high desert just because it was dry. But it's actually navigable water because
Wow.
we interpret it to be such.
Yeah.
So you go to jail, or you pay a huge civil fine, or you can't use your property. Any of those things which you had no knowledge of.
You know something, Roger, that's a really good segue into this other part of what I wanted to talk to you about. I mean, I want to come back to due process, and we're going to talk about the takings cases before the high court.
Good.
But you talk about the issue of fines, and you
Yeah.
talk about the issue of criminality. And
Yes.
one of the things that I've spent a lot of time talking about on this show and elsewhere is the issue of intent. The first time I ever learned about the difference between general intent and specific intent was sitting next to you and working on all kinds of issues. Talk about that issue, the issue of intent, and how we've lost intent, not just in environmental law, but in a whole host of areas of criminal law, and how that's changed our society.
Yeah. Traditionally, when you go to law school and you take first year criminal law, you are taught that there is a so-called mens rea requirement, and that's the Latinization of intent. That if someone does something but doesn't really intend to, then it's normally not criminal. Well, with the expansion, the explosion of the regulatory state, and that really underlies everything you and I are talking about today.
Right.
With the explosion of the regulatory state, the regulation of every aspect of our lives, and some aspects we haven't even thought of yet, we find ourselves facing the prospect that we are in violation of the law. In fact, I dare say that it's almost difficult to go through, it's very difficult to go through a day
Right.
without violating some law or
Sure.
regulation of some kind, totally unintentionally. Well, with these regulatory violations, and they can be civil, meaning that you usually pay a fine, or you may be under some sort of limitation in what you are allowed to do with your business, your property, or they can be criminal with the usual penalties of not only fines, but going to jail, and going to jail for years. Those kinds of violations, if they're violations of regulations, have been held to be strict liability crimes, or
Yeah.
crimes without intent, meaning that you did it, even if
Yeah.
you didn't intend to do it. If you disturbed a wetland, if you injured an endangered species or the habitat of an endangered species,
Right.
even though you didn't know that there was an endangered species around, and you had no knowledge of what kind of habitat they inhabit anyway, you can still be held liable for civil penalties and even criminally for those actions. It's that which has sort of put us in a position that it's really up to the prosecutor whether you are going to jail or not, and there's not a heck of a lot you can do about it because I would venture to say impossible
Yeah.
for everybody every day to avoid violating any regulation, because there are millions of them out there.
Yeah, Henry Silverglade wrote the book 3 Felonies a Day, in which he talks about this. I talk about that quite a bit. And you know, it reminds me of Lavrenti Beria, the head of the Soviet secret police, who said,
Yes.
"Show me the man and I'll show you the crime." It's a very scary place to be. Let's go back to this then, Roger, because I want to talk about the elements of substantive and procedural due process.
Sure.
And there is a debate over whether or not there are different kinds of due process. Where do you stand on this? And I remember this because when we would be working on briefs having to do with takings cases and dealing with issues like ripeness and the exhaustion of administrative remedies, one of the things we almost always talked about was the issue of due process.
Yes.
I'll have you explain it because you're a better explainer at this than I am. But please talk about
Well,
this.
yeah, due process is really at bottom a sense of fairness,
Yeah.
a sense that the justice system, the governmental system, is working properly, and the law tries to define uh, certain basic elements of due process. Uh, Traditionally, we define it as notice and a fair hearing, right? So if you don't know what the law is, you haven't received notice, then you really shouldn't be held responsible for complying with the law. And if you uh, go before a judge or a jury or an agency that has its mind made up before you ever get a hearing, then you really haven't had a fair hearing. And you can just elaborate those two principles into what we would normally refer to as due process. And that's contrasted with the story of Emperor Trajan back in Rome, who promulgated laws, but he put them way high up on a column, a stone column, where nobody could read them.
Sure.
But he could always say, "Oh yeah, it's up there. That's
Right.
what you did was against the law." And if only you could, if only you could
Sure.
see it up there on the top of the column, then you'd know that you were in violation. And that gets us back to the 3 felonies a day that you're talking about. That who can possibly take the hundreds of thousands or millions of pages of regulations and statutes and know what it is you are or are not required to do.
Right.
And that doesn't even get into the whole notion of agencies that give short shrift to the processes that are required by statute,
Oh yeah.
or the fundamental notion of just what is due process, and have they given you a fair hearing? Have they given you a fair shot? And Andrew, this does actually take us back to Chevron. If the
Right.
agency starts with, "Hey, my interpretation is what prevails here.
Sure.
I don't care what you have to say about
That's right.
your interpretation of the statute or the regulation, because I, the agency, have already made up my mind." Well, is that really due process at all?
Well, and that's why early on in the Trump administration, you and I haven't really talked about Trump. We don't need to sort of go down that road. But early on, in the first week of the Trump administration, one of the first things that the White House did was they issued their executive order on regulatory transparency and accountability. This idea that you couldn't be prosecuted criminally for things like interpretations and guidance documents, something I know you've dealt with both in justice and afterwards. The idea of things that are not regulation in nature, but are interpretations, the wetlands delineation manuals we used to deal with. And then the Biden administration turned around, and one of the first things they did was got rid of this executive order. That the idea of transparency and accountability is vitally important. Tell us a little bit about that.
Well, it's vitally important because the government works for us. That's the fundamental premise of our republic, of our constitutional system, and if you want to use the word democracy, which gets misused all the time now.
Hear, hear.
But fundamentally, the idea is we are not servants of the government. They are servants of us. Well, you can imagine a servant who says, "I'm not going to tell you what I'm doing." Oh, maybe they're in charge. Your accountant says, "I'm not going to tell you what I'm doing with your money." Or the person who's responsible for caring for your kids says, "I'm not going to tell you what I'm doing with my kids."
No,
Well, come on, you don't. It's the other way around. They are our servants. And The only way we know if government is living up to its responsibilities, constitutional, statutory, and ethical for that matter, is if we know what government is doing. And to the extent that they are hiding their actions from us, that they are putting up shields and lack of transparency, lack of accountability, we don't have a republic. We don't have a constitutional system.
So let's turn our attention to another executive order, that being 12630, the executive
My
order
favorite.
on takings. Yes, well, and rightfully so. And talk about the genus behind that, what it's supposed to do, and frankly, how many of these agencies are ignoring it today.
Yeah. Well, as I said, during the 1900s and up to the time of the Reagan administration, there had been a general ignoring of the constitutional requirements for protection of property rights. The Supreme Court in 1987 issued 3 decisions, a trilogy, that began to breathe life once again into the constitutional protections of property rights. And the White House decided, and President Reagan signed, Executive Order 12630, which requires every agency before issuing a major regulation to consider whether it is a taking of property rights or not. And to this day, that rule, that executive order rather, is in force. If you look at the Federal Register and you look at the bottom of the major regulations, they will recite, along with compliance with the Regulatory Flexibility Act and the Paperwork Reduction Act and several other statutes, or several other executive orders rather, they will recite that they have complied with Executive Order 12630. Now, unfortunately, an executive order is only as good as the respect that government agencies, government bureaucrats give it. It is not enforceable by a court. You can't go to court and say, I want to enforce this executive order, because it is merely an order from the president to the executive branch, the people that work for him, or the agencies that fall under him. So fundamentally, we are seeing very little compliance with Executive Order 12630. And it is generally considered to be not subject to the Freedom of Information Act, so we can't even demand the analysis that is supposed to be done, the takings impact analysis that the agencies are supposed to do. So it's one more area in which, if we had transparency, Andrew, we would be seeing how the agencies are analyzing and why it is and how it is that they are concluding that, as best I can tell, no regulation since 1987, when President Reagan issued that executive order, no regulation has ever resulted in a taking, although that's not what the court said.
Obviously, yes. That's funny. And, it's interesting because on things like Reg Flex and paperwork reduction, there's a push being made, because I'm helping to make the push, that the National Ombudsman for Small Business, their office should be taking a much greater look at compliance with those things. We should find some agency or some entity to take a look at EO 12630. So let's talk about the takings cases that are before the High Court.
Yes,
because that's so very timely.
Well, there are 2 very interesting cases. First of all, last year we had a couple of very important property rights decisions. One of them out of Minnesota invalidating as a taking the county's practice of foreclosing on people. In this case, a 90-year-old lady who lived in a little condominium had gotten behind on her property taxes.
Oh, yeah.
The county foreclosed on her condominium and then sold it for a profit and kept the results.
Yeah.
Not, Not just paying the taxes, but rather the county said, hey, we did pretty well. We made some money on this.
Oh, yeah.
Well, the Supreme Court held that.
Let's go take some more property. Yeah.
Yeah, exactly. So this year, what do we have to look at this year? Well, one of them actually kind of ties into what we were just talking about. That is another way in which government is scraping off money. It's Sheets versus El Dorado County, California. Mr. Sheets wanted to get a permit to place a modest mobile home on a parcel of property that he owned. And the county said, fine, you can do that. But we have this traffic impact fee that's going to cost you $24,000 to get your permit to put your modest mobile home on the property that you already own. And Mr. Sheets said, whoa, wait a minute. I'm not going to contribute to any traffic. I guess he's going to drive back and forth to his mobile home once in a while, but he's not creating a traffic problem. It's not like he's doing, say, a big housing development or an apartment building that's going to have a lot of residents and contribute lots of cars. And they're going to have to widen the roads or whatever. So the court in California, where else, held that because the legislature had created this fee as a statute, it would be invalid if the zoning board simply imposed it on the individual. The Supreme Court has already gotten there in a case called Coons out of Florida, where the Supreme Court said you can't just say, if you want to use your property, you got to pay the government.
Sure.
And you can't do that because it's called an unconstitutional condition on the exercise of a constitutional right.
Right.
The government can't charge you for exercising your religion. They can't charge you for exercising your right to freedom of speech. They can't charge you for getting due process, and they can't charge you for using your property.
Interesting.
So that is the issue that the Supreme Court has taken up, and once again addressing the sort of precedent question that you talked about. The Supreme Court is going to look at the question of whether just because the fee was adopted by a legislative body rather than imposed by the zoning board, which is termed a quasi-judicial activity, is it legal? Is it constitutional?
Sure.
Same fee, and the same lack of any nexus to the use. That is, there's no traffic problem being caused by placing this mobile home. Nevertheless, does it make a difference just because of the way in which government imposes that fee?
Right.
And we think it does not. And that's what we're hopeful the Supreme Court is going to decide. The second case that the Supreme Court has agreed to hear comes to us out of Texas. Procedurally, it's a little tangled, but fundamentally, the issue is this. If an individual has his property taken, in that case, the state of Texas constructed a highway that flooded and destroyed the plaintiff's land. And the plaintiff said, hey, the state of Texas has taken my property. Well, the district court and the Court of Appeals said, that may be so, but in federal court, you can't sue the state of Texas. You have no claim against the state of Texas. There isn't a statute
Right.
creating that cause of action. And so there's no, you may have a constitutional right, but you have no way of vindicating it.
Wow.
The issue the Supreme Court has agreed to hear, and I think this too is a lead pipe cinch, this a dead bang winner, is that whether the Constitution itself creates the cause of action. Otherwise, the government can simply say, oh yeah, Constitution says we got to pay you, but you don't have any way to sue us to get paid. And that is, at a minimum, a denial of the just compensation entitlement under the Constitution. It's probably a denial of due process as well, because there's no process.
Right.
So it is unusual for the Constitution to create the cause of action, but in the federal system, where all of these taking cases are considered by the Court of Federal Claims, which is a specialized court that hears monetary damages claims against the federal government, that court has long since held that the Fifth Amendment actually creates the right to just compensation on itself, by itself, and that's where your claim comes from. We think the Supreme Court is likely to adopt that same analysis with respect to the states, and that the state of Texas can't say, "Hey, we're immune. You can't get us. You can't make us pay you the just compensation that you're entitled to under the Constitution."
You know, Lord love it. You would hope that Texas would do better, but I guess
I know
guess
we
not.
expect more. We expect more of them.
So, Roger, you guys at the Marzulla Law Firm, you've got a couple of really interesting cases going on, having to do with the fishermen and the offshore wind. Talk about that.
Well, we have, and in fact, just this week on Tuesday, 2 days ago, we filed suit on behalf of the county of Cape May, New Jersey, and an environmental group and several fishing groups, challenging the way in which the government has hastened, like bulls in a china shop, to approve this offshore wind business. And they've done it under the aegis of executive orders. We were talking about executive orders. On the first day of this administration, President Biden issued an executive order saying we are going to build thousands of offshore wind turbines up and down the Atlantic coast. Now, these are not little turbines. These are not little structures. The turbines that were approved offshore of New Jersey and offshore, but not that far offshore, are over 900 feet tall above the ocean surface. That's about 3 times the height of the Statue of Liberty.
Right.
It's twice the height of the Washington Monument. These are huge structures, and they're going to build thousands of them. They're going to pave over thousands of acres of ocean bed with boulders and rock that are necessary to secure the foundation for these things. And there are many other problems, not least of which, talking about the fishermen, is that it excludes them from their fishing grounds and imposes huge safety problems for them. As we discussed earlier, they are out there in perfect storms, in fog, in wind, in nor'easters, in 20, 30-foot waves, and all sorts of conditions. And if you're out in the open ocean, at least you're pretty well assured you're not going to run into anything.
Right.
But if you have hundreds or thousands of these structures that are set out there willy-nilly without regard to how they impact navigation, how they impact fishermen in the fishing industry, you've created a major safety problem.
Sure.
There's a second problem in that these fishing boats, which are out there for weeks or months at a time, also use radar to navigate. With the whirling turbines, which at
sure.
the ends are whirling at over 200 miles an hour, actually disrupt radar.
Sure.
So you're causing problems for the fishing boats to actually be able to navigate, let alone to be able to use their fishing gear, fishing nets, and other methods. Plus, they're simply excluded from their fishing grounds because these huge monuments are placed on 1 mile apart locations. So you can't really get a fishing boat to go in there and poke around, try to get in between these huge structures.
Yeah, folks, you have to understand that these fishing lines that these fishermen use can be miles upon miles long, and
that's right.
The nets are massive, and so it's not a mile between windmills may seem like a lot, but it really isn't. It's really literally like threading a needle, isn't it, Roger?
Well, it is, and you don't turn a boat like you can turn a car.
Right.
These fishing boats, which are pretty good sized as well, need a lot of space to make turns and to maneuver, especially when they have nets, and they simply can't do it. And they made those comments, submitted studies to the government agencies, and were basically disregarded. So that's the issue for the fishermen. It is a huge issue for the county of Cape May, because the majority of their income is derived from tourism. And studies indicate that people don't really enjoy the seashore as much if they've got these big turbines just offshore.
Let
alone during the time that they're building them.
So and then on that note, it's there's a former delegate from the state of Maryland, Don Murphy. This has always been his big issue down in Ocean City, Maryland. So he's going to hear you say that, and he's going to perk up.
Well, they're coming to Maryland. When I say and down the Atlantic coast, this is from Maine to North Carolina. The government has handed out leases of several millions of acres of seabed, that is pristine seabed, and that's why one of the environmental groups, the Clean Ocean Action, has also joined in this lawsuit with us to challenge the way in which the agencies have shortcut, using this executive order, have shortcut the environmental review. So without doing any environmental impact analysis, the government agencies leased millions of acres, chose where these turbines are going to go, where these huge wind farms are going to go, and has now completed the process for 3 of the proposed sites, and there are probably 14 or 16 more that they plan to get done within the next year or 2.
Well, Roger, we wish you the best of luck there. Listen, I want to take, before we let you go, I want to take a moment of personal privilege here. And listen, I don't think I've ever adequately thanked you for the assistance you gave me and the mentorship and tutelage. I do not think I would be doing the work that I'm doing either the media work, but most especially the policy work that I do, had I not spent that time working with you at Akin Gump and afterwards. So thank you very much from the bottom of my heart for all of that.
Well, you're very kind, Andrew, and I, in turn, will thank you for the tremendous service that you gave during that time, and congratulate you on the wonderful work that you're doing today.
So, Roger, they can find out more at Marzulla.com. Is that the website for the law firm?
That is the law firm's website, Marzulla, MARZULLA.com.
Well, Roger Marzulla, thank you so very much for joining us today.
My pleasure, Andrew. Thank you.
This has been yet another episode of the Lunch Hour with Federal Newswire. I am your host, Andrew Langer. Please, if you're watching us, go and check out the podcast on all the major podcast platforms. If you're listening, check us out on YouTube. And please enjoy the rest of your lunch.
This has been the Federal Newswire Lunch Hour Podcast, hosted by Andrew Langer. Check out the Federal Newswire's family of websites, as well as their social media stream